Along with Matt Vandenberg, I am one of the co-chairs of the Moot Court program this year. It is my distinct pleasure and honor to welcome you all to this, the final round of the 48th annual Dean's Cup competition. Initiated in 1963 by two deans of the law school, the Dean's Cup has come to represent and showcase some of the very best in appellate advocacy at Duke Law. We're extremely happy to be presenting this final round to you today. And before we get started, I'm going to tell you a little bit more about the history and structure of the Dean's Cup. Then you'll hear a little bit more from my co-chair, Matt Vandenberg, about the distinguished panel of judges we're very fortunate to have here today. You'll hear from Karen Beach, one of the Dean's Cup coordinators this year, who will tell you about the finalists, and then from Grayson Lambert, who will tell you finally about the structure of the problem that will be argued today. As I said, the Dean's Cup has come to represent some of the very best appellate advocacy, including both written and oral advocacy at Duke Law School. We're very confident that the final you'll see today represents some of the very best appellate advocates that we have in the student body of the school. The structure this year of the Dean's Cup was slightly different from what we've done in the past. Grayson and Karen implemented a structure whereby the preliminary round competitors argued by themselves. Then from those 43 individuals, 16 were chosen based on how well they did in oral advocacy in the first rounds, and they were power matched to constitute teams of two in the quarterfinals. These teams then argued, wrote one brief for one side, and then argued against the teams from the other side, and the scores were compiled based on how well they did in the quarterfinals, and the best two teams advanced to the final. The teams we have today, therefore, have argued this case many times over the last few months, know the case very well, and are going to do a fantastic job today, we're confident. Before we get started, I want to thank first the Dean for his extensive support and help and guidance to make sure the Dean's Cup, first of all, stays on track, and second of all, make sure that it remains a very high priority for the Moot Court Board and the school in general. The Dean works very hard to make sure that we get excellent judges to come and judge the Dean's Cup this year, and of course in years in the past, and we're very thankful for his continued support. Finally, I want to thank Karen and Grayson for doing a fantastic job, first thinking through all the different structural changes that we implemented this year, and second, spending countless hours putting those changes into practice. They were very, very devoted and patient dealing with Matt and me. I'll definitely say that. And we were very fortunate to have them. So thank you guys very much. Thank you very much, Dean Levy. And now I'll turn it over to Matt Vandenberg to tell us about the judges. Thank you.
Good afternoon, everyone. As Ben said, we're very happy today to have with us a quite distinguished panel of judges. Information about them is in your program, but I'd like to highlight the information so that you can appreciate what an honor and privilege it is for the students who are in the finals today to be arguing before these judges, and what a great opportunity is for Duke Law School as well to have them here. First, we have the Honorable Brett Kavanaugh from the U.S. Court of Appeals for the D.C. Circuit. Judge Kavanaugh was appointed to the U.S. Court of Appeals for the D.C. Circuit in 2006. A graduate of Yale College in 1987 and Yale Law School in 1990, he served as a law clerk to Walter Stapleton of the U.S. Court of Appeals for the Third Circuit and for Alex Kaczynski of the U.S. Court of Appeals for the Ninth Circuit. In 1992 and 93, Judge Kavanaugh worked as an attorney in the Office of the Solicitor General of the United States. He served as a law clerk to Justice Anthony M. Kennedy of the U.S. Supreme Court during the court's October term in 1993. From 1994 to 97, and for a period in 1998, Judge Kavanaugh was Associate Counsel in the Office of Independent Counsel Kenneth W. Starr. Judge Kavanaugh was a partner at Kirkland & Ellis in Washington, D.C. from 1997 to 1998, and again from 1999 until 2001. From 2001 until 2003, he served as an Associate Counsel and then as Senior Associate Counsel to the President. From July 2003 until his appointment to the court, he was Assistant to the President and Staff Secretary to President George W. Bush. Since joining the court, Judge Kavanaugh has taught courses at Harvard Law School as well as Georgetown University Law Center. The Honorable Judge Reena Raggi of the U.S. Court of Appeals for the Second Circuit was appointed to that court in 2002. For the 15 years prior to her appointment, she served as a U.S. District Judge for the Eastern District of New York. She graduated Phi Beta Kappa from Wellesley College in 1973 and received her J.D. cum laude in 1976 from Harvard Law School, after which she served as a law clerk to Thomas E. Fairchild, then Chief Judge of the U.S. Court of Appeals for the Seventh Circuit. From 1977 to 1979, she was an associate at Cahill, Gordon, and Rindell. The judge then served as an assistant U.S. attorney for the Eastern District of New York from 1979 to 1986, where she headed the office's Narcotics and Special Prosecution Section. In 1986, she served as the interim U.S. attorney. From 1986 until her appointment to the Eastern District in 1987, she was a partner at Windells, Marks, Davies, and Ives. In 2007, the Federal Bar Council for the Second Circuit honored her with its Learned Hand Medal for Excellence in Jurisprudence. She currently serves as a member of the United States Judicial Conference's Committee on the Federal Rules. And the third member of our panel today, the Honorable Denis W. Shedd of the U.S. Court of Appeals for the Fourth Circuit. Judge Shedd was nominated to the Fourth Circuit in 2001 by President George W. Bush and confirmed by the Senate in 2002. After graduating Phi Beta Kappa from Wofford College in 1975, Judge Shedd attended the University of South Carolina School of Law, receiving his J.D. in 1978. He then earned an LLM from the Georgetown University Law Center in 1980. Judge Shedd served on the staff of Senator Strom Thurmond from 1978 until 1988, including as chief counsel and staff director of the Senate Judiciary Committee from 1985 to 1986. Judge Shedd spent several years in private practice and as an adjunct professor at the South Carolina School of Law before being appointed as a U.S. District Judge for the District of South Carolina by President George H.W. Bush in 1990. He served as a district court judge until his elevation to the Fourth Circuit in 2002.
Good afternoon. As Ben explained, the Dean's Cup consists of 3 rounds: the preliminary round, the quarterfinals, and today's final round. This year, more than 40 students competed in the preliminary round, and needless to say, we are extremely grateful to all the alumni and faculty members who volunteered their evenings to judge the preliminary round. They judged the competitors with fairness and enthusiasm, and we would like to recognize their efforts on behalf of the Moot Court Board. Those alumni and faculty who judged in the preliminary round, please stand and be recognized. The new format of this year's quarterfinals required faculty members to spend 5 hours judging the competitors on a weeknight. We were very thankful for the positive response from our faculty members, who embraced the new format and gave so generously of their time. Thanks to their dedication and skill, we are confident that the 4 students who will argue here today are 4 of Duke Law's top oral and written advocates. Our faculty judges and brief graders are a credit to this institution, and we would like to thank them now for all the time and effort they devoted to this year's Dean's Cup. The 16 students who advanced to this year's quarterfinals did not choose their partners for that round. It is a testament to the skill and collegiality of our student body that those 8 teams worked together under intense pressure and time constraints to write full-length briefs and make their oral arguments as a pair. The 16 quarterfinalists are listed on the last page of the programs. We invite them to stand and be recognized at this time. Now I will introduce this year's Dean's Cup finalists. Representing the petitioner, Catherine Lawson and Phil Rubin. Catherine is a 2L, originally from LA. Prior to attending law school, Catherine worked at a nonprofit in Washington, D.C., where she developed training materials for female electoral candidates in Jordan, Pakistan, and Egypt. At Duke, Catherine serves as a staff editor for the Duke Journal of Comparative and International Law, a member of the Moot Court Board, and as president of Duke's chapter of the North Carolina Bar Association. Catherine will be a summer associate at Parker Poe Adams and Bernstein in Raleigh. Phil is a 3L from Marietta, Georgia. He graduated from the University of Georgia with majors in political science and international affairs and a minor in music. Prior to law school, he worked for a national service fraternity, teaching leadership to college students at universities across the country. At Duke, Phil is editor-in-chief of the Duke Law Journal and co-chair of the Class of 2011 Gift Committee, and he served last year as academic chair for the Duke Bar Association and as a lead fellow. After graduation, Phil will clerk for David Sentell, Chief Judge of the United States Court of Appeals for the District of Columbia Circuit. Representing the respondent, Sarah Boyce and James Harlow. Sarah is a 2L from Belmont, North Carolina. She graduated from Davidson College with a major in English. Before law school, Sarah was a core member with Teach for America in Washington, D.C. At Duke, Sarah is a legal writing teaching assistant, co-chair of the Education Law and Policy Society, a lead fellow, and a member of the Moot Court Board. She was also recently elected editor-in-chief of the Duke Law Journal. This summer, Sarah will work for Gibson, Dunn & Crutcher in Washington, D.C. James is a 2L from Stony Brook, New York. He graduated from Johns Hopkins in 2007 with a double major in history and political science. Before law school, James worked for the Department of Justice as a paralegal on white-collar criminal cases. At Duke, he has worked as a research assistant for Professor Beale and served on the Moot Court and mock trial boards. Also, he currently serves as an articles editor for the Duke Law Journal. This summer, James will work in Washington, D.C. for a law firm and for the Department of Justice. Now my co-coordinator, Grayson Lambert, will introduce this year's problem.
Hey, we're excited you're all here and for what's going to be a great final round. We've had a problem this year that brought out difficult legal questions, but also ones that are easily accessible by someone who doesn't know the law and doesn't know the problem that well and can follow the arguments. Essentially, like many states, Illinois has a specialty license plate program. In Illinois, an organization can petition the General Assembly to get a specialty plate, have the General Assembly approve that plate, the governor sign the legislation into law, and then the Secretary of State is charged with the administration of the license plate program from that point. The Secretary will begin the production of a plate once there's been an interest expressed from about 750 citizens of the state of Illinois. And then in working with the organization to design the plate will go into production once the requisite number of signatures are present. Choose Life Illinois is a nonprofit group that seeks to promote adoption as an alternative to abortion. Like many other nonprofit groups in Illinois, Choose Life sought a specialty plate, but the General Assembly refused to approve the legislation. At that point, Choose Life filed suit in federal district court, claiming that the General Assembly's decision not to pass the statute and the Secretary of State's refusal to produce the plate violated their First Amendment rights. The district court agreed with Choose Life that specialty plates are private speech rather than government speech, and that the state's action violated the First Amendment. The case then went on to appeal to the Seventh Circuit, where the Seventh Circuit agreed that it was indeed private speech on specialty plates, but disagreed with the district court, overruling it, saying that specialty plates and the rejection of them does not constitute a First Amendment violation. So, Choose Life then appealed to the Supreme Court, which leads us here today. We look forward to hearing Phil, Catherine, James, and Sarah argue this case, and we look forward to our distinguished panel of judges giving them all they can handle up here. I would like to remind you to please turn off your cell phones so that that doesn't disrupt the proceedings. And before we start, Karen and I would like to thank Matt and Ben for all of their hard work and help through this process in what's been an exciting year and promises to be an exciting last hour. So without further ado, ladies and gentlemen, the final round of the Dean's Cup.
The Honorable, the Chief Justice and Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Good afternoon. We have just one case on the calendar this afternoon, Choose Life Illinois Incorporated versus Jesse White. We'll hear from the petitioner.
Madam Chief Justice, and may it please the court, my name is Phil Rubin, and I, along with co-counsel Catherine Lawson, represent the petitioner, Choose Life Illinois. At this time, I'd like to reserve 14 minutes for my co-counsel's argument and 2 minutes for rebuttal. The the First Amendment stands opposed to government regulations which favor some speech, but disfavor other private speech. Here, Illinois created a specialty plate program absent any content-based criteria in the legislation. While the state approved every single license plate application up until the case that resulted here, the state disapproved of Choose Life's message by refusing to grant its plate. Now, the Seventh Circuit was correct in finding that
The action is done by the legislature, is that right? The action you've just complained about?
Yes, Madam Chief Justice.
But you're suing the Illinois Secretary of State and no one from the legislature, is that right?
That's correct, Your Honor.
So what relief are you going to want us to give you?
Your Honor, the relief that we would ask for in this case, it could come in several forms, would be to direct the state to produce the Choose Life plate, which has met the other criteria.
Direct who in the state?
Your Honor, looking to this court's precedent with things like state sovereign immunity and so on, the court hasn't necessarily been concerned with state separation of powers. So ultimately, it would be up to the state to determine whether, in order to address this court's ruling, it would need to pass a bill or change its law or simply have the Secretary of State issue the plate himself. But ultimately, the court's ruling would have to be followed by the state either way, and the petitioner trusts that the state would follow it. Now, the Seventh Circuit was correct in finding that specialty plates are private speech, yet it erred in failing to properly...
Now, you assert that this is, that the government doesn't control the text, isn't that correct?
Your Honor, sometimes the government has some input on the text, but in general...
But in this case?
In this case, no, Your Honor. The government has not, at least has not stipulated any requirements or any discussion pertaining to what the message would be.
But doesn't the Secretary of State have to approve the license plate?
Ultimately, the Secretary of State, under the old policy, would have to have approved the plate. The state, during this litigation...
I'm talking about the design and what's on the plate. Doesn't the Secretary of State still have to approve that?
The Secretary does, but even according to the Secretary's office, and this is the Director of Driver Services, the only things his office looks at relatively to graphics, for the most part, is visibility of the license plate for law enforcement purposes.
Is there anything in the record where he discussed specifically who controls or edits the text that goes on a license plate? Not the design of it, not the color of it, not the visibility, but specifically the text, the words on the license tag.
There's nothing in the record that comes to mind here. Now, the legislature has, in very limited circumstances, stipulated certain things regarding the text.
I'm talking about this tag.
This tag, no, Your Honor. It didn't reach that point.
Let me ask this of you. When you assert that the government doesn't control the text, is that assertion based on the statute, which I don't think says much about it, or the regulations, which I mean the Secretary's rules about that? Is that what is the basis for your assertion of no government control? Or do you think it's the facts in this case?
Your Honor, it would be the facts in this case, specifically. And now, we don't know what the government would have done if it had reached the point where the Secretary would be discussing the text on the plate. It didn't get that far. But Choose Life isn't here complaining that the state has messed with or changed the message itself. It simply rejected the message outright.
How is this different than the government choosing, say, 100 messages that it's willing or wants to promote, and saying that anyone who wants something special on the license plate has to select one of those government-approved messages? How's this case different from that?
That would be different in terms of the beginning origin, Justice Kavanaugh. So here, the government has not made any stipulation as to what its message might be. Now, even if it picked 100 different messages, you could still say that the government chose a message. Here, that's precisely what this program does not do. The government did not pick any message of any kind and simply said private groups...
Well, it picks it when it approves it, though. Right?
It does, Your Honor.
How's it different from saying we're going to pick some approved license plates, we'll take suggestions from the public, but ultimately the government's going to put its imprimatur on a certain set of Illinois values that will be reflected on the license plates?
Well, Your Honor, it shows the difference between this and Johans, because in that case, the government had beginning to end control. What you described would be only end control. And
You know, Johans is the executive branch acting, correct? This
That's
is
correct.
the legislative branch. And do we have anything in the record that suggests that this action is taken by the legislature in anything other than the normal course? Namely, whatever group wants a license plate has to find someone in the legislature to sponsor a bill. That sounds like a purely legislative action to me.
In that sense, Madam Chief Justice, it is, but for the First Amendment's purposes, that would allow states to shield from First Amendment scrutiny any decision that they move up to the legislative level. And indeed, it would counsel
You mean
states to do so.
state couldn't make a policy choice on what it wanted to say? Couldn't the state pass a resolution, divorce from a license tag, being pro-choice or pro-life? Couldn't the state do that by passing a resolution?
Yes, Justice Shedd, the state could absolutely do that, and that would be government speech in its truest form. That would be government deciding the message from beginning to end and government expressing
But
it.
don't we have to be practical about the legislative process, which is that, and indeed its democratic aspect, that members of the public who have an interest approach their legislators and urge certain legislation? And here that's what's going on. I'm troubled by the notion that we would not view this as government speech when it comes to us only as the result of legislative enactment.
Yes, Madam Chief Justice, but the difference here is the First Amendment, and that's what changes this analysis considerably. First of all, the First Amendment is counter-majoritarian. It stands opposed to being cured by simply allowing the legislative process to take its course. In fact, the First Amendment itself is not as much needed.
But only if it's private speech. And the question I'm putting to you, perhaps I didn't make this clear, is that when the legislature has to use its full power by having both houses enact something by the majority that is required for the action, that it's hard for me to view that as private speech. What am I missing here?
Well, Your Honor, the two things that are missing are that the speech is attributed to private drivers and that the message is created by private organizations. Indeed, this court has said in Woolley v. Maynard in 1977 that a message on a license plate is associated with the driver and it constitutes speech by that driver.
Well, a bumper sticker, of course, is associated with the driver, but isn't the license plate itself different in the sense that the state has the authority to set what goes on the license plate? Obviously, if the state started prohibiting bumper stickers that said certain things, that would be an entirely different case.
Well, not according to this court's precedent, and even according to the record and statements by the state. Now, first, in this court's precedent, in Woolley v. Maynard, the state of New Hampshire mandated the state motto be on every plate. So that was clearly a government message in that sense. But still, nonetheless, this court held that the government could not require people to not cover up that motto on their plate.
That's where we were talking about not compelling speech. Here you're talking about the government having to offer options of speech on the license plate. I mean, what does your client want a license plate as opposed to a bumper sticker other than for the state's imprimatur?
It's not, Your Honor, just the state's imprimatur. It's also the sense of permanence that comes from adopting a plate, which is not something you can readily change out as easily as a bumper sticker. It's also the sense of formality. A lot of people don't like to put bumper stickers on their car, but it's more than that.
You can take a license tag off a car a lot faster than you can some bumper stickers out there.
But you'd have to go and purchase a new one, which also goes to the fact that a considerable
Purchase
expenditure.
a new one, what, bumper sticker or a license?
A new license plate, which goes to the other aspect of it, which is the considerable expense. But it's more than that. It's the right to be treated equally in this forum.
Let me say this. You've said that you focused a lot on origin of the text, isn't that correct? Isn't that correct?
Yes, Your
In
Honor.
your argument? You just, in answer to a question, you said here the citizens came up with this language. Is there any evidence in the record of that? I couldn't find any in the joint appendix that any person other than a legislator came up with this language. Is there any evidence in the record to suggest that evidence was given to those legislators?
Your Honor, there's nothing that I can point to in the record, but the Choose Life organization has been litigating this case across the country, and the plate is in over half the states.
But the answer is there's nothing in the record on the very point you're arguing to us, because you focused on one of your major factors is where the text originated. And you just said in answer to a question that people gave this language to the legislature or something, but there's there's not anything in the record to indicate that, which I think you've just agreed to.
No, Justice Shedd, and maybe I need to clarify.
Okay.
The private organization here took 25,000 private petitions, and that is in the record, and submitted them to the Director of Driver Services. Now, when they submitted them, legislative action was not required. The statute was amended.
No, I know, but that's not the question. The question is, and we can get on past this. I can find nothing in the record which indicates that the legislators who introduced the Choose License Tag bill had any communication or received any text from the group. Am I incorrect about the record or not?
I'm simply unable to say where those legislators got that text from.
Well, if the legislators came up with it by themselves, doesn't that make it more fall in the category of government speech?
No, Your
And why wouldn't it? And why wouldn't it?
No, Your Honor, and in this case, I would look at the exact text, Choose Life. It's the name of the private organization to whom the money would go from the plate. So it would be an amazing coincidence if legislators made that text by themselves and it happened to be the name of this private organization that sent in 25,000 petitions.
Where's it in the record that the money would go to them? I understand that money over and above the costs is earmarked for particular groups, but all I saw in the record was the request that it not go to pro-abortion groups. I didn't see that it would go to your group. Did I miss something?
To their cause, Madam Chief Justice. Now, I think if this
Where
had
is
gone
that?
to not pro-abortion groups being
Right, but that doesn't mean that it couldn't go to any of a number of health groups or unrelated groups. That's a legislative decision, right?
It is, Your Honor, but we didn't get there. There isn't anything in terms of where it actually would have gone.
You
And
just told us it was going to your group, and that's not clear from the record that it would go to your group.
it's simply not clear. Choose Life would certainly have wanted that to be the case, but we didn't reach that far in the legislative process. But that goes to the core of this issue, and I don't want to turn away from Woolley too far, because in that case, it was a compelled speech case. The government can't compel itself. It's private speech, because in order for it to have been coerced speech, for Woolley to have been coerced by the state.
No. The government can adopt government speech and then try to compel a private citizen to repeat it.
But then
That's what that case is. That's what that case is about, government speech that is being compelled. Are you suggesting that the motto on every license tag in that state was private speech?
At the very least, Justice Shedd, according to the court in that opinion, it must contain some private portion. And the court said in that case that when you see a car on the road, you associate the message on the plate with its driver.
Did we say in that case at all that the motto on that tag was anything other than government speech, the motto being on the tag?
Your Honor, the government speech doctrine had not formed at that point, so government speech was not mentioned in there at all, nor was this distinction between government and private. But the court.
Speaking of which, you advocate, I think, a four-part test that we adopt to distinguish government speech from private speech.
Your Honor,
Why would we do that? That test that you're talking about seems to me circular in parts and unhelpful in other parts. Why don't we just ask what a reasonable observer would think the speech in question is, government or private?
Well, Your Honor, in fact, the reasonable observer test might be the easiest and simplest way, and the petitioner argues that that comes out on this side. Now, the Fourth Circuit test, Sons of Confederate Veterans, has worked very well for the circuit courts, who have been almost entirely in agreement. But we are not arguing.
Almost entirely, but actually in disagreement. The Sixth Circuit disagrees on how to apply it, right? The Ninth Circuit and the Fourth Circuit are on the other side, but there's been a lot of disagreement about how to apply it. And it seems to me some of these factors, degree of editorial control, who's the literal speaker, who's responsible, really don't advance the ball much.
Can you tell us which circuit cases involve legislative action?
The circuit cases that involve legislative action, I know ACLU of Tennessee versus Bredesen involved legislative action. And Sons of Confederate Veterans did not. I would have to check the record to give you.
I meant in the context of an abortion speech. One, the Confederate Veterans is the flag case, right?
Yes, Your Honor.